are again present. Where'd Ms. Sager go? Oh, there you are. I'm sorry.
Yes, Your Honor.
All right, ready to proceed?
Yes, Your Honor. I'd ask the Court's indulgence in permitting me to interpose objections if necessary on Ms. Savage's behalf, even though she's not a party, given the nature of the inquiry and I'm sorry. Given the nature of the inquiry and that she is not a lawyer, to the extent that any questions might stray into forbidden areas or go beyond the Court's foundational, permissive foundational inquiries, I'd like the Court's permission to interpose objections.
All right, what I'll allow you to do, Ms. Sager, is to stand to the side of the witness stand, and if you wish to confer with your client, I'll allow you to do so.
Thank you, Your Honor.
All right, Mr. Ullman?
Thanks to call Tracie Savage.
All right, Ms. Savage?
Please stand by the court reporter and raise your right hand. You do solemnly swear that the testimony you may give in the cause of opinion before this court shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Please have a seat in the witness stand. And please state and spell your full name for the record.
My name is Tracie Savage, and it's spelled Tracie Savage.
Mr. Ullman?
Thank you, Your Honor. Ms. Savage, what is your occupation,
I'm a television news reporter.
and by whom are you employed?
I work for KNBC TV here in Los Angeles.
And were you employed by KNBC in that capacity in September of 1994?
Yes, I was.
On September 21st, 1994, did you broadcast a news report related to the case of People versus O.J. Simpson?
Yes, I did.
And in that news report, did you report information with respect to some socks that had been allegedly recovered from Mr. Simpson's bedroom?
That's correct.
All right, and what did you report about those socks?
I reported that the socks had been discovered at the defendant's home and that there was blood on those socks and that the socks had been tested, the blood on the socks had been tested, and the results showed the blood belonged to Nicole Brown Simpson.
And did you report any information with respect to the nature of the tests that had been performed?
Yes, I did.
And what was that?
I reported that a DNA test had been conducted.
And that the results of that DNA test had been reported?
That is correct.
Now, I take it that in making that report, you were reporting what you believed were accurate information?
I reported accurately the information that was given to me from multiple sources.
All right. How many sources?
I'm afraid I cannot answer that question. That is protected by the Shield Law.
But you are asserting that what you reported was an accurate presentation of what the sources had told you.
That is correct.
And were these sources knowledgeable about the investigation of the case of People versus O.J. Simpson?
Check. That calls for conclusion.
Sustain. I think what you can do is ask if she in fact reported that these were knowledgeable sources, and then ask her for what her definition is of knowledgeable.
Thank you, Your Honor. Did you report any information about the knowledge of the sources whom you were quoting in this report?
Yes, I did report that they were knowledgeable sources.
And what did you mean by knowledgeable?
They were sources, and this has been stated already on the record, close to the investigation.
So these sources then were the source of your information that socks had been recovered from Mr. Simpson's bedroom?
Calls for conclusion, opinion.
Sustain or phrase the question.
When you reported that socks had been recovered from Mr. Simpson's bedroom, you were relying then on these sources who were close to the investigation?
I reported accurately the information that was given to me from multiple sources, reliable sources.
And it was these sources who informed you that socks had been recovered from the bedroom.
That was part of the information that the sources had given to me.
And it was these sources who told you that the socks had blood on them.
That is correct.
And it was these sources who told you that the blood on the socks had been tested.
That is correct.
And it was these sources who told you that the tests had revealed a match to the blood of Nicole Brown Simpson.
That is correct.
And it was these sources who told you that the tests that were conducted were DNA tests.
That is correct.
Now, did you make any promise to these sources that their identity would be kept confidential?
I gave my word as a journalist that I would not reveal their identities.
And this is true with respect to each of the sources that you spoke to?
I gave my word to my sources that I would never reveal their identities.
And you gave that word explicitly? You told them, I will not reveal that you were the source of this information?
Yes, that's true.
Now, were these sources persons who had given you information in the past?
That is true.
And the information they had given you in the past was also related to the case of People versus O.J. Simpson?
Your Honor, if I can interpose an objection here, I know this is somewhat unusual, but this, I think, goes well beyond what the court indicated Ms. Savage would be asked to testify about, which was merely the foundation that she is a reporter, that the information came to her in the course of her news-gathering activities, and that she made promises of confidentiality. With all due respect, Mr. Ullman is now conducting the very inquiry of Ms. Savage, which the court has not yet determined he's entitled to conduct.
Well, Your Honor, we would maintain that this is information that has already been disseminated. In the letter to the court from KMBC, it was represented that the reports were based on the sources with
Counsel,
different...
I agree with you that I'm already aware that that is the representation that has been made. The issue is to establish the foundation for invoking the SHIELD law, and then I have to make a determination going beyond that once we get to that point. Question's premature.
Now, could you tell us what you mean, Ms. Savage, when you indicate that your sources were close to the investigation?
Same objection, Your Honor. We're beyond now the scope, and I think the foundation has already been laid. There's no need to go beyond what Ms. Savage has already testified to.
Oh, well, how do you define generally knowledgeable and close to the investigation?
Your Honor, I'm afraid by identifying how I determine what knowledgeable is, I may in effect reveal the identities of my sources. Knowledgeable, I think, in all due respect, I think the word speaks for itself.
Mr. Ullman?
Well, Ms. Savage, did you assume that the information given by your sources was accurate because they were close to the investigation?
Well, that's not relevant. It
Yeah,
calls
we're
for
beyond
conclusion.
the scope of the inquiry at this point.
Did your sources include any officers or agents of the Los Angeles Police Department?
I respectfully decline to answer that question. I must assert the SHIELD law.
Again, Your Honor, he's now asking the questions beyond foundational questions.
No, the foundational question, one of the foundational questions were, if you were asked what the sources were, would you invoke the SHIELD? That's where we are. That has been now accomplished. Mr. Ullman?
All right. And at this time, then, you decline to indicate any of the sources on whom you relied for the report of September 21st?
That is true at this time.
Nothing further.
All right, thank you, Mr. Ullman. Mr. Goldberg, do you have any questions? Certainly. All right, Ms. Savage, thank you very much. All right, the court will make a finding that a preliminary foundation has been established. The court will take under submission the Delaney issues.
Your Honor, we would like to call Michelle Kessler with respect to those issues.
Is she available?
She was on
I
notice.
believe she's on phone.
Well, the last we heard, Michelle Kessler had gone this morning to a doctor's appointment for a neck injury that she received
All
earlier.
right, let's do this. As far as Michelle Kessler is concerned, as I indicated to counsel in chambers this morning, one of our other jurors has a medical appointment tomorrow at 4, that we have to conclude at 4 o'clock. Tomorrow. So why don't we schedule that, and since tomorrow is a 6 o'clock day, let's schedule Michelle Kessler for 4 o'clock tomorrow afternoon.
I'd also say about Michelle Kessler, Your Honor, perhaps to short-circuit this, the defense might make a specific offer of proof as to what she can supposedly testify to on this issue, because my understanding, and counsel also had the opportunity to interview her at length, is that she doesn't have any personal knowledge as to the circumstances surrounding this fax and when specifically the leak occurred, and that she only knows these things based upon what she has heard from
But
others.
she may also have knowledge about any internal investigation that may have been conducted. She may have participated in that investigation. She may have been interviewed. There are a lot of things she can tell us about.
And of course, the position of the Los Angeles Police Department, as we have been advised previously, is that all of that is official information under 1040, and that the defense must use the provisions of 1040 in order to try to get that information.
Well, I'm sure we'll see the city attorney tomorrow afternoon.
Your Honor, just.
All right, counsel, what we'll do then now, we'll shift back to Mr. McDonald. We'll bring the jurors down. As I indicated to Mr. Cochran and to Mr. Darden, the court would like to personally inquire of the juror who fell ill last week, just to assure myself that the juror can continue. All right, Mr. Neufeld.
Two scheduling matters.
Your Honor, we do have one other witness who will be brief on this issue.
Who is that?
Joseph Bosco.
As to the shield issue?
Yes.
All right, what's your offer as to Mr. Bosco? All right, good morning, Mr. Shapiro.
Good morning, Your Honor. Thank you. Your Honor, Mr. Bosco will offer testimony that he also was a recipient of similar information, that he is a professional journalist, that he has been assigned a permanent seat by Your Honor in the courtroom to cover this case.
No, that's a misnomer. It's a regular seat. There's nothing permanent about it.
Permanent to this date.
Yes,
He has regularly attended all the courtroom sessions.
he has.
And he has published an article that reported the same information that reporter Savage has just testified to, and that he will confirm that he is a recipient of information from a source that told him that DNA test results were in on the socks that were
When?
recovered in the bedroom
When?
in about the same date, September 21st, and that information came from a member of the Los Angeles Police Department who is known to him as a badged member of the police department and a person who is active in this investigation.
All right, do you have, this is published information?
Yes,
And what's the publication?
Penthouse Magazine,
All right, what issue?
the July issue.
All right, so you want to call Mr. Bosco regarding that?
Yes.
All right, Mr. Bosco is present in the courtroom. Good morning,
Yes, he
sir.
is. He is under subpoena.
Morning, sir.
All right, do you have counsel, Mr. Bosco?
Well, Your Honor, I've been through this down in New Orleans for about a year and a half, and I have counsel down there. I've been through this process. I mean, I couldn't call my attorney in New Orleans who's handled this thing on another case for me for 2 and a half. I think, he may holler at me, but I think I know the issue well enough to take the stand, because I've been through it before, whatever. I might be nice that I call him, or maybe my mother will do so watching the television. Or my wife, I don't know. But whatever your wish is, sir.
No, the wishes are on your behalf, sir. If you wish to have counsel to confer with before you're called as a witness, given the nature of the issue, I'll give you leave to do so. If you feel no need to confer with counsel, we can proceed. It's up to you, sir.
Could they just have a few minutes to call in?
Absolutely.
I mean,
Why don't you do this?
I'm not denying, I mean, I will.
Mr. Bosco, let's do this.
Yes, sir?
Why don't you report back to the court when we come back after lunch at 1 o'clock? I'll give you plenty of time to locate your counsel in New Orleans.
Yes, sir.
All right? Confer with him by phone. If you feel it's necessary to have local counsel, we'll accommodate you. All right, so why don't you take care of that when we recess? All right?
Yes, sir.
Thank you.
All right.
There's also the issue of the Gretchen Stockdale tape. When is the court going to hear that?
Well, I think I have my plate full with this particular issue. Don't you agree?
This should be a no-brainer, Your Honor, frankly, on the tape.
Well,
Excuse the colloquialism.
well, you'll make a much better judge than I ever will if you think that's a no-brainer. All right, we need to take a recess to bring the jury down. All right, we'll take 10 to bring the jury down. Parties are again present. Record should reflect that the court held a chambers conference with the juror who fell ill yesterday. Oh, I'm sorry. I have to say it again.
The real time is not working.
I don't know. I hear they may go on strike. All right, back on the record in the Simpson matter. All parties are again present. The record should reflect that over the recess, the court had the opportunity to meet with the juror who fell ill last week in the presence of counsel for both sides, and both the court and counsel, I believe, have assured ourselves that that juror is able and willing to proceed with jury service, continued jury service on this matter, and with just minor adjustments for ongoing medical treatment for that condition. So the court is satisfied with that inquiry. All right, Mr. Neufeld, you indicated there was something preliminary you wanted to bring up before we start with Mr. McDonald.
Good morning, Your Honor.
Good morning, sir.
Actually, even before I bring up the preliminary matter, just a quick scheduling issue.
Yes, sir.
It was suggested that perhaps we'd hear from Michelle Kessler at 4 p.m. tomorrow afternoon.
Correct.
Just so we're absolutely clear on this, it was the defense intention, Your Honor, that after we finish with Professor McDonald, that we would play the tape of Paratus, but that only takes about 10 or 15 minutes, that we'd hope to resolve the Savage-Kessler hearing testimony in advance of hearing Kessler's trial testimony. But Kessler was going to be the next trial witness after Tracie Savage, in front of the jury, that is. This just throws, a little bit of a monkey wrench into the works.
Well, here's the problem. Despite what Ms. Lewis might think, I don't consider this to be a no-brainer issue. It has very sophisticated issues, sub-issues, and it involves reviewing very carefully the record regarding materiality. This is not a decision that I'm going to make sitting here without any thought, contemplation, and going over the issues.
I'm sorry, if I can indicate this. Ms. Lewis was referring to the Gretchen Stockdale issue, not the Kessler issue.
Well, that's not the way I understood her comment.
All I ask...
And she's entitled to her opinion. If she thinks it's a no-brainer, like I said, she's much brighter than I am. Go ahead.
All I ask is that since we were proceeding internally
No,
under
I
that
understand.
premise...
But the problem is, counsel, what I'm saying is that I don't want to be pushed into making a decision on this faster than I have to.
No, I think what you're saying makes perfect sense. All I'm saying is we'd like to get back to sometime this afternoon if we have some small gap maybe we can move Kessler up to the early part of tomorrow afternoon if need be, or something. I'm just saying that we may have a little difficulty in filling that void with other witnesses who are prepared at this moment. That's all,
All right.
that's all I'm saying. I can report back to the court
I
later this
understand that.
afternoon with that information.
I understand that, and if we have to have a gap here and there, that's something we'll have to deal with. I understand Ms. Kessler, my clerk gave me a note that Ms. Kessler apparently has a personal funeral obligation tomorrow afternoon, so that may be a problem as well. I don't know.
Right, so maybe we could take her earlier then, so we wouldn't interfere with that obligation, if the court so desires.
If time permits, we will.
Okay.
Why don't we finish Mr. McDonald first?
All right. With respect to Professor McDonald, Your Honor, there is one brief point that I think has to be resolved before we resume the direct examination. You may recall that that the prosecution made a motion to exclude Professor McDonald's glove drying experiment. And at that point in time, Your Honor, when we had discussion and argument about that motion, and you ruled against the prosecution, you made some remark about, well, perhaps the Buffalo pictures might be displayed. Then you said, forget it. I was concerned about that remark because obviously the court was not expressing an opinion one way or the other. It's just something that came to your mind. We then became concerned that perhaps the prosecution might think, and I believe mistakenly, Your Honor, because I don't believe there's any legal basis for it, to use those photographs that they have chosen either because they chose not to for strategic reasons or chose not to because they believed they would be inadmissible. In either event, they didn't try and introduce those photographs as part of the direct case. That they might mistakenly believe that they could now introduce those photographs to cross-examine Herbert McDonald. I'm making this application now, Your Honor, because I want to be very, very clear to the court that it is our position that if the court will allow the prosecution, in a sense, to intimidate the defense into not going forward with this compelling evidence because of the prejudicial nature of those photographs or those videotapes, we will refrain from introducing the glove drying experiment. And that's why it is essential that we know before we complete the direct examination what the court's ruling on that will be. Now, the defense's right to put on a defense, if you will.
Well, let me see if I understand. You want to put on this glove drying experiment, which I have indicated that I'm going to allow you to do.
That's correct.
All right. But you are afraid that if during the course of Mr. McDonald's cross-examination the prosecution has photographs or videotapes of Mr. Simpson wearing gloves in, say, for example, winter conditions in Buffalo, you're worried that that will have some devastating effect upon your ability to present a defense?
Your Honor, no, it is.
Because when I made that offhand comment, which I should learn not to do, obviously, the only reason I mention that is that in establishing the materiality of your glove drying experiment, obviously those experiments were conducted upon the new gloves, the Aris lights, if I'm not mistaken, that the Aris Corporation was kind enough to provide to the court. The only issue being that obviously for cross-examination purposes, I could do this cross-examination in 10 questions, one of which would be, did you use new gloves? Did you take into consideration shrinkage that occurs over a period of time? Did you take into consideration the tanning methods, the silicone impregnation of leather to prevent moisture problems, that sort of thing, and then show a picture of the defendant wearing gloves in winters? I mean, that's pretty simple, wouldn't you say?
Well, yes and no, and I'll tell you why it's not, Your Honor.
Right,
You
tell me why it's not.
may recall when I was examining Robin Cotton, and I started asking some questions about swatches heating up in the back of a truck in Brentwood, and you wisely cut me off and said, what is a New York lawyer doing asking questions to a Maryland scientist about weather conditions in June in Brentwood? Well, that was a good point on your part. But equally true, Your Honor, I don't know how much people in Los Angeles know, because of the luxury of living in this climate, about wearing gloves in the cold Northeast. And I can tell you, Your Honor, and anybody else who wears gloves in the Northeast will tell you, that we wear gloves out in the snow, we wear gloves out in the rain, and they don't shrink. We do that all the time. We bring the gloves back in our houses, and they don't shrink. And then we wear the same gloves for years and years and years when we're adults, and the only reason we replace them is because we lose them or misplace them, not because they shrink. The only testimony you heard, in fact, on the shrinkage issue came from Richard Rubin, who said specifically that, in his opinion, if you did dump them in a lot of liquid, okay, and then, depending upon how quickly they dried and those circumstances, that could cause some shrinkage. But remember, we're not talking about some shrinkage here. We're talking about, by the prosecution witness's own testimony, 10 to 15% shrinkage. And there's been no testimony at all from any prosecution witness during their case that weather can account for a 10 to 15% shrinkage. None at all. Freezing and thawing doesn't do it. When I go out in the winter, when I lived in Wisconsin and it was 30 below zero, those gloves are freezing and you come inside, they thaw out. They do not shrink. Gloves don't do that.
Mr. Neufeld, let me ask you this, though. Isn't this sort of premature, given the fact that they're not obligated in cross-examination and impeachment of your witness to divulge what they have? And I've indicated to them that before they present anything similar to what we've just talked about, that we'll have a motion at sidebar to determine whether or not that's going to be used.
No, I think, Your Honor, it's not a question of them showing particular photographs right now. I'm not asking for that. What I'm saying is that this entire line of inquiry would be impermissible, showing any photographs or any of videotapes, because there was absolutely no foundation that was laid during their case at all that the weather conditions can account for a 10 to 15% shrinkage. In fact, the only theory proffered by the prosecution during their case was that gloves smeared with a large quantity of blood could account for a 10 to 15% shrinkage. That's the only theory they advanced, and it's because of Mr. Simpson's Sixth Amendment right to confront that theory, to put on a defense, that we engaged Herbert McDonald to conduct that experiment after the prosecution rested, just for that narrow purpose. They have a right to do their own shrinkage experiment. I don't have a problem with that. We've opened the door to that. But there is no question in my mind, Your Honor, that photographs showing Mr. Simpson wearing gloves at a Buffalo Bills game, at a Cincinnati Bengals game, in the winter, does nothing at all to cross-examine or impeach this witness's testimony. If they wanted to do experiments on blood, that would. But merely showing that he wears gloves in the outdoors in the winter doesn't do it. There is no evidence to suggest that wearing gloves in the winter will cause a 10 to 15% shrinkage. I know of no such person who would ever testify to something like that. And so what the prosecution is really trying to do here is simply prejudice the jury, not with probative evidence to explain shrinkage, but rather with shots of Mr. Simpson wearing brown leather gloves.
Okay, hold on. Is there a response from the people?
I don't know what kind of gloves Mr. Neufeld wears. He must be very magical gloves. I think everybody in the country has written to us about the shrinkage that occurs when you wear gloves in the winter. I lived in New York. I know what happens to gloves when they get wet and then they dry. Mine shrunk. I don't know. I'd like to buy the kind that Mr. Neufeld gets. They're great. But as far as I know, my experience, and I think that of millions of Americans, is that gloves, when exposed to weather, shrink.
That's not the issue. The issue is, do you intend on presenting evidence of Mr. Simpson wearing gloves in wintertime?
Why do we have, does the court requiring us to tell them that now?
No, I'm not. But you could save me a lot of trouble if you said, no, we're not going to do it.
I can't promise you that, Your Honor.
All right.
I really can't. No, I mean, I think it's, you know, all kidding aside, it's obviously germane. They undertook to do these experiments on brand new gloves under totally different conditions. That's fair grist for the mill on cross-examination. We didn't tell them to conduct the experiment in this manner. They've set themselves up for a fall by doing it in the way that they did. You pay your money, you take your chances. And that's all we're saying.
So I take it your position is that since it is cross-examination, at this point, it's not something that you need to divulge in discovery.
That's correct.
All right, but we've seen when this glove issue came up in the commercial news media, we saw several sportscast replays of Mr. Simpson in wintertime
That's true.
wearing gloves.
That's true.
All right. Can you establish a foundation that those gloves are the same gloves?
Yes, I can.
Interesting. All right. Let me see counsel at sidebar without the court reporter. All right, thank you, counsel. Mr. Neufeld?
Yeah, Your Honor, the only additional point I wish to make is I'm making a specific proffer so the court will know at least the parameters of Professor McDonald's testimony on this issue. I laid out most of what he would say in my moving papers with the accompanying photographs which the court saw. I just want to be very, very clear to the court that Professor McDonald took the other new pair of gloves that were provided by the Isotoma Corporation, basically identical to the new gloves that Mr. Darden used in the second demonstration in the courtroom, and that he took them and smeared as a large amount of blood on both gloves, as much as they would absorb, in fact, rubbed it in, that he then tried to replicate the climatic conditions at Bundy and Rockingham for that evening by relying on U.S. Weather Service reports regarding temperature, dew points, humidity, the like, that he used a special humidity chamber, in fact, designed by the Corning Glass Company to do that, and that as a result of that experiment, he simply learned two things. One, that the approximate drying time is about 4 hours, and that two, when he compared the gloves after they were dried to their size before they were moistened with the blood, that there was no observable shrinkage. And that would be the extent of his testimony. And so it's our position that, since that's all he will testify to, that they are precluded from cross-examining him with any photographs or videotapes showing Mr. Simpson wearing brown leather gloves.
All right. Counsel, I think that if you bring in evidence regarding this experiment as to how these gloves did not shrink under your experiment, the prosecution is entitled to cross-examine on factors that were not taken into consideration during the course of the defendant's experiment, such as the age of the gloves, other weather exposure, the particular materials that were involved in this with this particular glove, the nature of how the leather was manufactured, what kind of water repellency treatments were placed on it, whether or not any of these things were taken into consideration. I think that's fair game for cross-examination.
The only little point I would add, Your Honor, is that I don't doubt that they have the right to cross-examine him on all those points and ask him whether he took those into account. By the way, the only little remark I would make is you may recall that Richard Rubin testified that these gloves were made with naked leather. That was his word. And so there are no preservatives. There are no there's no chemicals to resist moisture or anything else. So the fact that it's just naked leather is not going to change over a period of time.
Well, there's some chemical constituency in the tanning process, but go ahead.
But we're not disputing, Your Honor, that the gloves in question are older gloves and are not new gloves. The jury's seen the gloves and they know they're older gloves. That entire cross-examination that you just described would certainly be permissible, but the ends of that
and would only take about 10 minutes.
But the ends of that cross-examination is qualitatively and quantitatively different from enabling the prosecution to show photographs of Mr. Simpson wearing brown leather gloves in the winter. We're not disputing that, that gloves are worn in the winter, that Mr. Simpson has worn gloves in the winter. 3/5 probably of the population have worn gloves in the winter. That's not a very probative point at this time. However, showing him wearing brown leather gloves is very prejudicial, and I don't see, Your Honor, quite frankly, the relevance of showing him wearing gloves on a cold winter day in Buffalo has to do with the rest of the cross-examination, which is perfectly permissible, about did you take into consideration that the gloves are old, did you take into consideration that it may be out in the weather?
Well, when I discussed this issue with counsel previously, I indicated that before any videos or photos were presented during the cross-examination that the court would have to see them first and make a ruling at that time. So the objection at this point is premature.
Well,
but given the parameters of what I've indicated, I think you understand the court's ruling.
One second, Your Honor. I'd just like the record to reflect that without the ruling that I believe we're entitled to at this time, then the defense will not introduce that glove drying experiment through this witness.
All right, well, that's a tactical decision that you're making based upon not knowing the results of a ruling that has yet to be presented, an issue that has yet to be presented to the court, and that the prosecution not being obligated to present that to you, since it's impeachment, this is a tactical decision that you're making on behalf of your client. So I just want the record to be clear.
I understand that, Your Honor. I just believe that I think under the Sixth Amendment, we have a right to a ruling beforehand.
All right. Okay. Let's have the jury, please.
I wanted to mention that the comment I made earlier was with regard to the Gretchen
Counsel.
Stocktail motion.
Let's put that to rest.
Well,
That's,
I'm sorry
I'm
for
not
the
even
ambiguity.
thinking about that right now, counsel. Let's have the jury, please. Gentlemen, please be seated. Now, the record to reflect that we've been rejoined by all the members of our jury panel. Good morning, ladies and gentlemen. First, I'm happy to see all of you back here today, and you all seem to be fit and ready to proceed. Secondly, my apologies to you for keeping you waiting so long, but we had a number of interesting legal issues that I had to deal with before we were able to continue with Mr. McDonald's testimony. All right, Professor, would you resume the witness stand, please? All right, the record should reflect that Professor Herbert McDonald is again on the witness stand undergoing direct examination by Mr. Neufeld. Good morning, Professor.
Good morning.
Sir, you were reminded that you were still under oath, and Mr. Neufeld, you may continue.
Thank you. Good morning, ladies and gentlemen. Now, Professor McDonald, in this case, you mentioned, I believe, last week that you were retained by the defense. Did you not?
Yes, I did.
Okay, and you are, of course, testifying at this trial. Is that right?
Yes, obviously.
All right. Now, could you please give us an estimate, over the last 2 years, approximately how many cases have you been retained either by the prosecution or the defense?
Probably somewhere between 50 and 75, more likely the 75.
And do you have an estimate about the approximate percentage, which would be cases where you were retained by the prosecution, and an estimate as to the percentage of cases where you were retained by the defense?
I would say about 50% for the defense and perhaps 40% by the prosecution, and 10% might be private or other investigations that would be civil rather than criminal.
Now, of all those cases that you just described, the 75 to 100 cases in which you were retained to examine and analyze evidence, and approximately how many of those cases did you actually come to court and testify at a trial?
About 10%. That might be high. I do not testify that often in court.
Sir, is one of the reasons that you testify so rarely compared to the number of times that you are retained because your findings did not help the side that retained you?
Sustain, rephrase the question.
Okay. Do you know the reasons why you testify so infrequently comparatively to the number of times where you're actually retained by one side or the other to examine and analyze evidence?
Yes.
Overruled. The answer is yes.
Yes.
And could you please tell us what the reasons are?
Overruled.
The reason is that when I'm asked to investigate a case and examine physical evidence or go to a crime scene, there are times when there is absolutely no evidence that can be useful in determining what occurred. The evidence may be too old, it may just not exist. And so if there is nothing that I can conclude that is of any value to either side, naturally I cannot write a report, I cannot give any information. On occasion, when I investigate a case for the defense and the findings would not be helpful, they do not call me to testify.
Now, what I'd like to do is resume the discussion we were having on Thursday concerning the ankle stains on sock 13A. I'd like to show you, Professor McDonald, Defendant's Exhibit 1278, 1277, and 1276, which you had looked at last week. Do you recall that when we left off last week, you were explaining your observations regarding the ankle stain on sock 13A?
Yes, I do.
Okay. Now, based on your observations, Professor, and expertise in the area of bloodstain interpretation, what conclusions did you reach concerning the stains on the ankle of sock 13A?
Well, I concluded from Exhibit 1276 that the overall stained area, which surrounds the cutout portion, was the result of a transfer of blood to that area and not projected. It's a very large stain, and blood does not spatter in that large an area. It might splash, but it doesn't spatter. That would take a very large volume of blood. But this is transferred to the surface of the fiber on the outside. And looking at 1277, the photomicrograph taken by Dr. Lee and myself shows the high spots of the weave, the upper portion which are brushed with, which I believe has been identified as blood.
Professor McDonald, by the way, while you're giving this explanation, if you would be so kind, if you can hold up the photographs to the jury so they can at least see what it is that you're describing. Actually, why don't I use the...
Do you want to put it on the Elmo?
It might be easier on the Elmo.
This is 1276, if I'm not mistaken.
That's correct. Can you see that well, Professor?
Yes, I can.
Okay. So what were you saying you learned from your observations? What conclusions did you make beginning with this photograph, and then we'll move on from there?
Well, I concluded that the stain which surrounds the cutout portion, which is much lighter in appearance, in almost a yellowish red coloration on this screen, was the result of a transfer of a liquid to the surface more as a direct compression rather than a side or lateral movement, which we call a swipe pattern, because of the peripheral bonding of blood to the top of the fibers, which is shown in, I think it's 1277 more accurately.
Okay. And now with referring you to Appendix 1277. Based on your observations and expertise in the field, what conclusions did you reach about that stain on the outside perimeter of the area that had been cut out?
Well, as stated, the area to the left, circled in blue, is a reflection of a red glistening substance which has previously been identified as blood. And on the right side, in the lower right, there's a dark circle showing the area which is not glistening insofar as having a red coloration. That is just the black fiber which under high-intensity illumination appears to be white in this picture. But that's the void area, and the stains are on the surface of the fibers, and they're not distorted. They're very sharp, very clear. That is one of the things that I considered in the swipe-type pattern or transfer pattern that occurs.
Now, again, based on your observations of the socks and based on your expertise in this area, sir, what additional conclusions did you make regarding the stains seen in the sock area?
Well, the other red substance that I saw was not on the surface of this fabric. Maybe I could demonstrate better. I'm looking at the outside of what is called the left side of the sock. Whether it's a right sock or a left sock cannot be determined, but it's the left side in the ankle area.
I'm sorry, 1 second, Professor. Your Honor, could you just inquire with the jurors as to whether or not they can all see what Professor McDonald is doing?
I don't believe they can. All right.
All right.
I'm referring to the outside of the left side of a sock. Whether it was the left foot or the right foot, again, is not clear. This area has been cut out. It's stained and cut out. I continued the examination when the socks were lying flat on a table surface in the laboratory and observed additional red balls of blood on the inside of the side opposite this cutout portion. And that's what the greater enlargement that has been introduced, probably 1278, shows one of those bonded, dried, liquid red materials.
And are there any additional conclusions you've made regarding
yes.
the relationship of these stains?
That's what I saw. I hadn't got to the conclusion.
I'm sorry.
The conclusion would be, obviously, that if the stain directly opposite the cutout portion on the inside is in any way related to the stain itself, then the staining occurred when this material soaked through and stained the inside of the side opposite. I would conclude that is what happened.
Your Honor, with the court's permission at this time, I would like to pass around 1278, I believe, which I did not pass around to the jurors last week.
Certainly. If you'll hand that to juror number 1, please.
Can I give it to juror number 1?
Juror number 1. 1278 from Deputy Smith, please. All right, the record should reflect that each of the jurors has now had the opportunity to view Exhibit 1278. Mr. Neufeld.
Professor McDonald, what is it about the way that red ball is configured and bonded to the actual fiber that you find to be significant in that photomicrograph?
As I'm holding this, so the label on the back is up, to describe that little red area simply shows that it is a round, glistening, reddish, ball-shaped configuration which I interpret as being bonded to the fiber to its lower right. And that fiber is woven into the overall thread, so that that spot of red fluid dried, when it was wet initially, dried on a fiber bonded. Therefore, it is part of a liquid transfer and not a addition by flaking or powdering or something that may have broken off when a cutting occurred on the area above it.
And, sir, I hate to burden with you one more time, but it has been suggested that when you use your own socks, it may not have been completely clear for everybody. I will take one of Mr. Cochran's socks and have it next in order, Your Honor, which is
1279, I believe. 1279.
And could you, for demonstrative purposes, sir, simply describe to the jury where you saw stains, simply using this sock as an example? Hold it up, please.
Much better sock than mine. This area right here, in the ankle area.
I'm sorry, 1 second also. If, with the court's permission, may the
Why don't we
witness
have
step
it
down?
step down right to the rail here?
Yeah.
And please keep your voice up, Professor.
The general area of the outside on what I'm calling the left side of the sock, for my purposes of identification, this would be the right side, again, regardless of which foot it happens to be on. On the left side, the overall inch by inch and a half stain is seen on the surface. And when it's cut out, there is on the inside of the side opposite, it'd be the inside here, if we turned it inside out, this is where there is transferred liquid that's dried. And I interpret that as being part of the staining action here at the time this was wet and went through, without a foot inside, obviously.
There'll be an objection to that, Your Honor.
Or we'll I'm sorry, 1279? What about 1279?
Yes, 1279, I would ask permission actually at some point to substitute it if I could, since
Yes,
it's a generic item.
yes.
Thank you.
The objection is that the latter opinion stated by Mr. McDonald called for speculation, and that there's no foundation.
Professor, let me ask you a hypothetical. Assume that a doctor examined Mr. Simpson head to foot on June 15th, and there were no cuts, scratches, or scrapes observed on Mr. Simpson's ankles. Would what you observed on the sock, when you examined it, both with the naked eye and with the microscope, be consistent with a blood stain passing through one side of the sock to the other when the sock is not on the foot and is instead lying flat on a surface?
Yes, it would be consistent with that.
Overruled.
And why is that, sir?
Well, as I stated when I had the sock on this board, if there's something like a foot inside the sock, unless there's a tremendous hole right through the ankle, there's no way that anything can go from one side of the sock to the other simply by transferring from the inside, the left or outside portion, through to the inside of the opposite side or the right side.
Overruled.
Now, sir, over the last 40 years that you have been working with blood, have you investigated the drying time of blood on different surfaces?
Yes.
How is it that you are familiar with the various drying times of blood stains under different conditions?
Objection while asked to approach.
With court order, please. Thank you, counsel. Proceed.
Thank you. Professor McDonald, could you please tell the ladies and gentlemen of the jury, how is it that you are familiar with the drying times of bloodstains under various conditions?
The institutes that I began directing in 1973, of which there have now been 43, have an experiment where we do drying times of blood in fabric, on wood, glass, various surfaces. This is done in small volumes and in large volumes, and also with many fabrics. This is a routine experiment that has been done for many years. The amount of time required is such that for the larger pools of blood, we can't do that in a single day, so that was deleted from the fourth publication. We still do, in experiments 12 and 13, some of the blood that is spread out to see how rapidly it will dry, put on clothing, particularly fabrics that are difficult, like Arnell and nylon combinations, that appear to be stained on one side. In fact, they were stained on the other. So we're aware that there are very dangerous areas in looking at a sample of material and trying to identify which side was stained without doing the actual experiment. So we do this routinely. I've done it on, I don't know how many cases. I would say perhaps 100, 200, 300 cases where fabrics are involved. We will usually test the actual fabric to determine transfer characteristics and drying time. That's how I'm familiar with it.
And sir, based on those demonstrations and experiments that were conducted routinely in the institutes by your students that you just described, does the volume of blood on an object affect the drying time?
Oh, certainly.
And how is that it affects the drying time? Simply.
Well, the more blood there is, the longer it's going to take to dry, given the same surface area. A pool of blood that is contained, for example, in a bowl is going to take much longer than the same area, but a very thin film.
And sir, did you estimate the approximate volume of blood that originally existed on that stain on the ankle in 13A, sock 13A?
It's the same as 42A.
Yes.
Yes, I estimated the volume to be approximately 1 drop. It is not soaked through on the periphery. Those are the pictures we've seen, 1276, I believe. Or 1277, excuse me. That shows the blood on the surface, at least on the periphery. The center has been cut out, and it would have been slightly heavier. So that stain could be caused on that material, I would estimate, with just 1 drop, 50 microliters, perhaps slightly more or slightly less, but I would estimate 1 drop would be adequate.
Okay.
Oh, well,
Now, you said that the drying time is affected by the volume of blood. Is it also affected by the type of surface that the blood is drying on?
Yes, definitely.
For instance, does it make a difference whether it's drying on fabric as opposed to a glass table?
Yes, the fabric would act as a wick, so to speak, up to a certain point, and it would allow the blood to dry more rapidly. But if it's a thick fabric, it would act as a reservoir, and it would contain the blood and reduce the surface area, so it would dry slower. Blood spread out on a surface, just a tabletop or anything, if it's a thin film, will dry very rapidly. If it's a small spatter, a small 2 millimeter to 1 millimeter diameter spot, it will dry very quickly. Within a matter of a minute, you can just wipe across it, and it will be dry. So it depends a great deal on the surface.
Sir, even within that subcategory of surfaces, which we'll call textiles or fabrics, will there be variation in the drying time between different types of fabrics?
Yes, we conducted experiments of that type to present a paper to the American Academy of Forensic Sciences some years ago dealing with the effect of enzymes in detergents. Several years ago, there was Tide XK and all of these little bugs chewing up the stains.
Right. What I'm asking, sir, is not so much the chemicals that an item may have been treated with, but is there a difference in drying time, for instance, between synthetics and natural fibers?
Yes, we use those in that paper.
And all things being equal, given the other factors, what is the difference in drying time between, let's say, a synthetic, which the sock is of in this case, and cotton?
If you have a synthetic fiber, it is non-porous. It does not itself soak in a fluid. Notwithstanding, the fluid will soak in by capillary action or just a wetting in between the individual fibers. But a natural fiber, such as cotton, ramie, hemp, jute, some of those things, are porous. Wool, for example, is porous. Animal fibers are porous, but not to the extent of some of the natural fibers. So therein, you have soaking not into the weave, but also into the individual fibers. And again, that retards the evaporation or the drying above and beyond synthetics, where the blood is exposed, although in between some of the fibers which do not absorb blood.
If I was to try and distill that, at least for myself, Professor, would that mean that all other things being equal, that blood will dry more rapidly on a synthetic fiber than on a cotton fiber?
Of the same type of weave and thickness, yes.
And sir, is there a difference in drying time for blood if it is dabbed or smeared on a surface versus blood that has simply fallen onto a surface or dripped onto a surface?
Well, if the dripping blood actually penetrates the fiber and goes down into the fiber, it wets it, in other words, that will dry much more slowly than if you just have it on the surface where there's air can actually get underneath it through the fiber.
And I believe you testified so that in your opinion in this case, the blood stain found on ankle 13 is a result of a dabbing of the surface as opposed to blood simply dripping or spattering onto the surface.
Sustained. Phrase the question.
Okay. Is it your testimony, sir, in this case, based on your observations of the ankle stain, that the blood did not spatter onto the ankle area of sock 13A?
Yes, it is.
Is it your testimony, sir, that the blood got there by being the result of some kind of compression, some object brought to bear on the sock, and that object had blood on it?
Yes, it is.
Overruled.
Now, sir, in addition to those factors which you've already described, is there a difference between the time needed to air dry a blood stain versus when the stain is on material that is actually in contact with a living body, such as a sock pressed up against an ankle?
Yes.
And could you explain to the jury what the difference is in drying time?
Sustained.
Could you explain to the jury what effect it has on drying time for the item of clothing which has the blood to be in contact with a living human body as opposed to when it is air dried?
Objection, no foundation.
Sustained.
Sir, have you compared in the past, prior to your involvement in this case, the different times in which an identical blood stain will dry if it is air dried as opposed to being in contact with a human body, with material that is in contact with a human body?
Objection, that's irrelevant, so
Overruled.
they, in contact.
Overruled.
Yes, over the course of many years, I've conducted experiments where fabric was actually placed on a person's arm or leg, and blood was impregnated into that material. The drying time and the soaking through characteristics were the object of doing that experiment. I can cite at least one case where we did that using identical twins, so the blood groups would be identical.
And sir,
Overruled.
based on your expertise, does blood dry faster or slower when it's on material that is in contact with a person's skin when the person's living, as opposed to when it is simply air drying and not in contact?
Objection, insufficient foundation.
Sustained. Clothing is not all uniformly worn on a body, counsel.
I mean, we have a sidebar.
It's as directions I can give you, counsel.
all things being, based on your experiments, I'm sorry, based on your studies and experiments, even prior to your involvement in this case, all other variables being equal, is there a difference between the drying time of blood on a fabric that is simply in the air drying as opposed to blood on a fabric which is in contact with a living body?
Objection, no foundation.
Sustained.
Have you done experiments to answer that particular question prior to your involvement in this case?
That's been answered.
Overruled.
Yes, I have.
Could you please describe what experiments you've done of that nature where you would actually compare the drying time where all the other variables are identical except for the one variable being the fabric is against the skin of a living person as opposed to the fabric not being against the skin of a living person?
Objection irrelevant.
Overruled.
Yes, we've done experiments, as I stated, to determine both the drying time on a person and drying time of that fabric in air. And because living people are warmer than the environment, with the exception of some of the weather lately, you will have blood drying on the garment much more rapidly.
Overruled. I mean, sustained, answer stricken. Juries to completely disregard that last answer. Proceed.
Professor McDonald, well, let's go this way.
Professor, have you done any of these drying experiments on socks prior to this case? Synthetic socks?
Not on the garment in a sock configuration, no.
Thank you.
Have you done it on synthetics that are very sheer and light like the socks?
Yes?
And have those experiments done on sheer synthetics that are light and sheer like the socks been done where one part of the fabric is in contact with the body, picking up the body heat, and the other fabric is simply air drying?
Yes?
And based upon those experiments, sir, what is your expert opinion as to which will dry faster?
Objection, no foundation.
Sustained.
All right. Professor McDonald, I'm now going to introduce. The prosecution has entered into a stipulation with regard to the next exhibit, which shall be
1281.
1281, which is the official records of the U.S. Weather Service, National Weather Service, at Los Angeles Airport for June 12th and June 13th.
Thank you.
Do you have a copy of these, sir?
Yes, I do.
To be corrected, 1280.
1280.
1280.
chance to examine the National Weather Service statistics for Los Angeles Airport for the evening of June 12th and the morning of June 13th, 1994?
Yes, I have.
Okay. And first of all, can you tell us, sir, what was the temperature range between approximately 10 o'clock in the evening on June 12th, 1994, and 9:30 the morning of June 13th, June 13th?
Objection, the report speaks for itself.
Overruled.
The temperature range was between 63 degrees Fahrenheit and 66 degrees Fahrenheit, according to the document I have.
And during that same period of time, sir, when you said the temperature range was between 63 and 66 degrees, does it also state what the dew point was?
Yes, it does.
And during that same period of time, sir, is there any indication from the official National Weather Service printout here that there was any dew on the ground on the night of June 12th into the early morning hours of June 13th?
Well, it indicates that the temperature, or the dew point range, was below the temperature range all the time, so there would have been no dew formation.
And how much below?
Objection, that's no foundation. Your Honor.
Sustained, answer stricken.
Could you please say, sir, what was the closest the dew point ever got to the temperature during that 12-hour period?
I'm sorry, counsel.
Objection, Your Honor.
Wait. You're having this witness testify to atmospheric conditions during the course of the...
No, all I'm having this witness do, Your Honor, is testify to...
This is beyond what he's qualified to testify to at this point, so the objection is sustained.
Your Honor, I believe that once the court takes
The
judicial...
objection is sustained, counsel.
May we have a sidebar, Your Honor?
No, you may not. Proceed.
All right. You said that the temperature between those hours of approximately 10 o'clock on the evening of the 12th and 9:30 the next day were between 63 and 66 degrees. Is that correct?
That is correct.
What is body temperature, surface body temperature, sir?
It's slightly less than,
Sustained. Surface body temperature?
Of a human being.
Sustained.
Are you familiar, through your studies, sir, on what the surface body temperature of a person is?
only that it's below the temperature of blood.
Objection, Your Honor. Objection, no foundation.
Overruled.
I'm sorry, could you please answer the question?
So it's below the temperature of blood, which is 100 degrees. Body temperature is 98.6. I think the surface temperature is several degrees below that, depending upon the environment. Because if it's a very cold day, your skin will be cooler than on a hot day. I think that's common sense.
To your knowledge, to your knowledge, sir, and based on your experience, will the body temperature of a living person always be greater than 63 degrees Fahrenheit?
And it is unless they're freezing.
Sustained. Excuse me, Professor, if there's an objection being made, don't
I'm
answer the
sorry.
question. Thank you. Proceed.
By the way, while you have those certified records in front of you, sir, are you aware of the fact that when Dr. Lakshmanan of the medical examiner's office testified, he said that on June 13th at about 1:46 p.m., the temperature was 64 degrees. Page 32052 of the transcript. Was Dr. Lakshmanan correct or incorrect when he gave that testimony?
Well, objection, Your Honor. That's irrelevant. It's also
Sustained.
not-
Dr. Lakshmanan was not at the crime scene, counsel.
Dr. Lakshmanan though, testified as to what the actual temperature was.
He wasn't there, counsel.
Your Honor, may we at this point recess for lunch?
Certainly.
And may we also have a sidebar?
Yes.
Thank you.
All right, ladies and gentlemen, we're going to take our recess for the lunch hour. Please remember all my admonitions to you. Don't discuss the case amongst yourselves. Don't form any opinions about the case. Don't conduct any deliberations.
Keep the noise down.
Don't conduct any deliberations till the matter has been submitted to you. Do not allow anybody to communicate with you with regard to the case. Stay healthy. See you at 1 o'clock.
I have furnished Mr. Morrell with a copy of the article, and I have no objection, certainly, to Mr. Bosco and Mr. Morrell taking as much time as they need to prepare this matter.
All right. Mr. Morrell, we have a 4 o'clock end of the court day today, so whatever, you're very familiar with these issues, I'm sure, so, good afternoon, sir. Yes?
Good afternoon, Your Honor.
I feel like I'm being tag-teamed today.
Well, I'm not here representing the ACLU, Your Honor. I'm here representing Mr. Bosco. And I was called on this matter 20 minutes ago, and I apologize for not watching this morning's proceedings. I was engaged across the street in the federal court. So I really am very much at sea in terms of what has already occurred. I don't want to be duplicative. I don't want to waste the court's time. Perhaps if we could arrange to take this matter up tomorrow morning, I would be at least more prepared at that point to address whatever the issues are.
All right, why don't you converse with Mr. Shapiro, who is the person interested in calling your client, talk to Mr. Bosco, and then let me know what your status is.
At the end of the day today, or, okay, but, all right, and I'll contact the clerk about that?
Yes. All right, thank you. All right, Mr. Cochran, good afternoon, sir.
Good afternoon, Your Honor. I would like, if I could, to put something on the record at this point, as I indicated to the court earlier. The court is aware that last week the court was kind enough to issue a subpoena for Ms. Laura Hard McKinney in North Carolina. And I had the pleasure of journeying to North Carolina on Friday morning, where I was able to read transcripts and listen to a very small portion of a tape. There are some 11 or 12 hours of tapes, Your Honor, regarding Mark Furman. The judge allowed us to listen to a very small portion of those tapes back in chambers. The thing that I wanted to call to Your Honor's attention and solicit Your Honor's assistance on, the court and Judge Wood in Winston-Salem, North Carolina, failed to give full faith and credit to the subpoena that Your Honor had issued on some basis that he felt this wasn't material. I argued strenuously, Your Honor, that after having heard the portion of the tape that I heard, and I can represent the court, it was Detective Furman's voice, and I can tell the court that these tapes and these transcripts were from a period April of 1985 to July of 1994. We didn't hear all those tapes. We heard just enough to make sure it was his voice. I also called this lady, Miss Laura Hart McKinney, to the stand, and she indicated this was Detective Furman's voice. These were tapes. She had met him in Westwood in 1985. He became like a technical consultant for her. And Judge, it is chilling, these tapes and what was said by this man in view of what he said here in court. He uses the term dumb nigger, niggers and Mexicans. He uses it throughout. And this is not in any storyline when he does that. He's talking about and giving her background about the LAPD and that sort of thing. I would think the LAPD would be very, very concerned. The title of the screenplay, of course, that she comes up with, Your Honor, is Men Against Women, MAW, this organization that we know, this clandestine organization that we know existed within the LAPD. But having gone through and taken some notes, I wanted to at least make a record, and I want to solicit Your Honor's assistance in something. In addition to using racial epithets and slurs against blacks and Mexicans and women, Detective Furman talks about his philosophy, disagrees with the LAPD philosophy. He shoots to kill, not to stop. He talks about arresting people simply because they're niggers. He talks, Your Honor, if you can imagine, about arresting a person, or stopping a black person in Westwood, and you ask him where he lives, and he says 22nd and Western. The court knows generally where that area is. And then he takes him into custody because he doesn't belong in Westwood. That when he wants to fabricate something to arrest someone, he takes the person's license, tears the license up, and then says, this person has no identification. It is absolutely frightening. He goes and talks about, and this is, you got to understand the time frame. This is near the letter to Kathleen Bell. there was a big concern at the time about feeding people in Ethiopia. And his response is he didn't care at all about feeding a bunch of dumb niggers in Ethiopia. On and on and on. It goes about chokeholds and niggers and on and on. It's absolutely frightening. And the lawyers for this lady were likewise taken aback. Everybody was. This court would. It is absolutely material because I don't have to remind this court that Mr. Bailey, in his examination, asked Detective Furman, had he ever used that word in the last 10 years, within the time frame, and was he as sure about not having used that word as he was about finding the Rockingham glove? You'll recall that. So it's very, very relevant. It's very, very material. 95% or more of what is on the tapes and in the transcripts have to do with Detective Furman and his background, not any characters or not any situation like that. He even talks, if you can imagine, about a lieutenant, a female lieutenant that we heard briefly about, who comes out to investigate Ma in West Los Angeles. And I think the court appreciates the possible relevance of that. We just ran out of time. This judge listened to this and said he'd heard enough. Everybody in that courtroom assumed, along with us, that this was certainly material, this was certainly relevant, that a man's life was at stake. In fact, near the end of the hearing, Your Honor, the lawyers for this lady said things like, we just want Mr. Cochran to make sure she's put up in a nice hotel and perhaps she can bring her husband with her. Everybody seemed to see the relevance except this honorable court there in North Carolina. Now, this is a bombshell. This is a critical bit of evidence for a critical witness in this case. It goes even beyond this case. It talks about a culture. It talks about so many of the things we've talked about. It talks about framing people, setting up people, falsifying reports. And so we need this lady out here. Obviously, efforts are going on to still get her here. We expect to file, if not by this afternoon, by tomorrow morning in Raleigh-Durham, an appeal, a writ of mandamus and a writ of certiorari to the Court of Appeals there. We will go all the way to the Supreme Court. We will go to the U.S. Supreme Court if we have to on this issue. I don't want to delay the proceedings. Your Honor understood the materiality of this, and what I'm going to ask you to consider doing is to give us a declaration regarding the materiality of these tapes, of getting this lady out here to California and in these proceedings. I will be glad to provide Your Honor with hopefully some authority with regard to that. After all, it was your subpoena, and you know these facts certainly better than a judge in North Carolina. And as an officer of the court, so do I. And so justice should not be thwarted by some bizarre decision by a judge in North Carolina under these circumstances. So we're not just going to take it laying down. We're going to move ahead. I have this morning been in touch again with the lawyers for Ms. McKinney. They're also back in California. So with the court, my request then today is to make the record clear of how strongly we feel about this. And how this man, the bottom line is, he's committed perjury. Should be investigated by an office other than the district attorney's office because of their alliance with this man, perhaps the attorney general, perhaps the U.S. attorney. Someone should investigate this for perjury. The police commission has to look at this because this whole aspect of everything that took place here, this is frightening and it's extremely serious. And those of us who heard this in that courtroom were chilled by what we heard and what took place. And so what I'm asking the court to do is assist us in getting this information, and I think perhaps a declaration, a further declaration regarding materiality might be the way to go, Your Honor.
All right, Ms. Clark, do you have a comment?
Your Honor, one other thing that I found,
Well, hold on, if they're confirmed.
okay, all right, I'll do it at that point. One other thing that I wanted to say before Ms. Clark started to speak. In one other very, very chilling reference that had nothing to do with any screenplay or whatever, there's a statement with his own voice of the ACLU and NAACP should be bombed. That kind of language, that kind of thought processes, that person who spent 20 years on the LAPD, and I understand he's about to retire, Your Honor, to move to this area in Idaho, is just beyond the pale, and we need your assistance. We're seeking to do justice here. The primary argument of counsel in North Carolina was that, the same argument you've heard here today, that she, as a journalist, she wanted to have some kind of right of privacy and didn't want to divulge this. But it has been divulged. You know, it's clear. We've all heard it, and I think that even the lawyers expected her to be here. Only the judge made this ruling, which we think is entirely inappropriate, and we're asking you to step in and assist us in that regard.
Ms. Clark?
My response is only a legal one. I don't know if this court can really make a declaration based on the representations of counsel, not having heard the tapes yourself, Your Honor. I don't know, legally speaking, what the proper response of this court could possibly be without firsthand knowledge of the material in issue. My review of the transcript to date indicates to me that there was a consistent position taken by the author that this was a screenplay, that Mr. Furman was requested to adopt a character for her in helping her to write this fictional account. This is not a documentary she was writing, Your Honor. It was fiction. And my understanding was that Detective Furman was furnishing fictional material for her as a fictional character. So I think that is important to the consideration of whether or not it's material, and I think the court should know what the matter is before adopting any position in terms of a declaration to oppose another court. That's the only thing I would indicate.
All right, Mr. Cochran, Ms. Clark raises a good point. One, the court issued the subpoenas under the Interstate Compact, and there's a procedure that this court and courts in the receiving states follow. And if the receiving state court made a determination adverse to the issuance of those subpoenas, then there's an appellate remedy, a written appellate remedy available in North Carolina. I've made the determination of materiality here. A judge in a different state has apparently made a different ruling. However, and I cannot in any way criticize that ruling from this vantage point, nor do I think it's ever appropriate for another judge to comment or criticize the rulings of another court, especially in matters that are pending. It's unethical and it's inappropriate. And Ms. Clark does raise the issue that I have not seen a transcript of those proceedings. I have, but you were there.
I was there, and as an officer of the court, I also, someone was kind enough to give us a copy of the tape. Let me indicate this to you. And I will ask the lawyers themselves to come down here tomorrow if you would like to. 95% of what's in these transcripts was not part of the play. This was Detective Furman speaking about his experiences as an LAPD officer, as a technical consultant. This was not any fiction. You think Men Against Women, that's not a fiction. Ms. Clark wasn't there, Your Honor. I was there.
All right, Mr. Cochran, here's the problem, though. The legal issue before the court, is there anything that the trial court here in California has the authority to do to enforce an out-of-state subpoena? The answer at this point, I believe, is no. I've issued the subpoena. It's gone to a reviewing court in another state, and that state has declined to honor that subpoena after holding a hearing. I'm not in a position, I don't think, I don't have any authority or jurisdiction to do anything more at this point, although I will confess to you, this is not a situation that has come before this court before.
It has not, and I'm thinking, Your Honor, about something analogous to extradition situations. And, you know, you made an interesting point, and we're not here to necessarily criticize anyone in another state. Obviously, we've got to go to North Carolina and appeal to another court, so we're not seeking to do that. But, Judge, you know, by this judge taking this decision, by making this decision, he somewhat criticizes your decision regarding materiality. And who, Judge, would know more about materiality in this case that you've been trying since September 26th? You or this judge back in North Carolina. So I just put that in perspective. I think you're being too kind. Perhaps I can say that. I mean, you would not know a lot more, and I don't expect you to criticize your brethren on the bench. But I think that what we're saying, and if I can give you some authority or some assistance, all we're saying is to ask you to give us something that further buttresses what we're talking about. This is not any fiction. This is the way this man lived. This is the way this man thinks. This is when he talks about Hitler celebrations and things like that throughout. And this isn't all of it, Your Honor. There's like 12 hours up until the time after he investigated these particular crimes that this thing went on. It is absolutely frightening. And what it is bottom line, it's perjury. It's absolutely perjury. He didn't claim any exception for anything. And that's what it boils down to. This cannot be allowed to stand. And so I'm really frankly surprised that Mr. Clark would even say anything. When we talk about a search for truth, this is the truth. We got his own voice, not anything anybody made up. It's his voice, his words. And so I think that if you would even just reaffirm your finding of materiality in light of these facts on the tapes, I mean, I think that's what we need. And I want you to give you some time to think about it. We want to get back to the jury. You'll think about it and then not rule at this point. You're never precipitous, and you wouldn't be now. And think about it. Let me see if I can provide you with something additional. Oh, after all, we're talking about your subpoena that they failed not to give. I didn't have a subpoena. It was yours, Your Honor. And so from that standpoint, I think we have an interest in doing the right thing here, being honest and pursuing the truth.
But, Mr. Carrigan, we have to put this into perspective. While I have the benefit of having sat through this trial every day since June the 22nd, so I know something about the facts and circumstances, that court heard the tapes, saw the transcripts, and talked to the parties involved, the author and her counsel. So that judge has more information than I do about the particulars.
Well, let me say this.
I decline you will not lure me into criticizing another judge.
No, and I'm not trying to get you to criticize anyone. I'm just saying I have a copy of the proceedings, so you can see those very easily. Let me tell you something, Judge. We went back into chambers for about maybe a half hour, and we read transcripts of the first 48 pages that talked about framing people and that sort of thing, tearing up a license, what you do for this. We read this, and we then listened to enough of the tape and then brought the client in to say, is that Mark Furman's voice? And of course it was. You got to understand, this happens from 85 up to 94. 90% of the information we never heard. But in talking to the lawyers who had heard this, they were very clear. It's nothing to do with any screenplay. This was background. There's perhaps one or two references about a screenplay. She then took what she wanted from him as a resource person. In fact, she talks to another police officer, too, somewhere on these tapes. This is far more to this than what the prosecution is aware of. This is a situation where these tapes ultimately must come to California, Judge, because it's critical to the defense. And as I said, we're going to take this all the way to the U.S. Supreme Court if she doesn't come forward voluntarily. But it's not, they cannot hide behind an absence of materiality. And I don't want you to criticize anybody. I just want you to stand up for what you believe. You know that Furman is material, as I've indicated. If a jury disbelieves his testimony, Your Honor, who could quarrel with the fact that's very important in this particular case, where he's committed perjury. And so that's what we're talking about here. So I'd like an opportunity to perhaps see if there's any cases that might assist us, anything analogous to this in the law that will help us.
All right.
And but I wanted to bring it to Your Honor's attention at the first available time.
All right. Thank you, counsel.
Thank you very kindly, Your Honor.
All right. Are we ready to proceed? All right. Deputy McNair, let's have the jurors, please.
I'm reminded to save time. I'll finish my direct in probably 10 minutes. The court had already ruled that before the prosecution can begin its cross-examination, they have to turn over for disclosure the impeachment material they intend to use before they begin the cross. In particular, transcripts of any other proceedings they intend to use have to be given to counsel. And also, Your Honor, it's my understanding that we agreed that before they go into any other cases, that we will have a sidebar on those issues as well.
That's correct.
Thank you. Minutes is going to be a brief recess to deal with some of those issues. Okay.
And Professor McDonald, would you resume the witness stand? Record should reflect that we've been rejoined by all the members of our jury panel. Good afternoon, ladies and gentlemen. All right, good afternoon, Professor.
Afternoon.
You're reminded, sir, that you are still under oath, and Mr. Neufeld, you may continue.
Thank you, Your Honor. Good afternoon, everyone. Professor McDonald, you may recall this morning I asked you a couple of different hypothetical questions. Let me begin by asking you another hypothetical. Sir, based on your observations of the sock and your expertise, are the wet transfer stains that you observed on the ankle area of sock 13A consistent with someone dabbing the sock with blood after it has been removed from Mr. Simpson's foot?
Objection, Your Honor, objection. It's only on the school's expertise and speculation, improper hypothesis.
Rephrase the question, counsel.
Hypothetically, sir, and based on your examination of the sock, and based on your 4 years of expertise in interpreting bloodstain patterns, are the wet transfer stains that you observed on the ankle area of sock 13A consistent with someone dabbing the sock with blood after it has been removed from Mr. Simpson's foot and spread?
Sustained. Problem is removal while it's not being worn.
Okay. You want me to rephrase it?
Yes.
Okay. Based on your observation of the socks and based upon your 40 years of experience in this field, sir, are the wet transfer stains you observed on the ankle area of sock 13A consistent with someone dabbing the sock with blood when it is not being worn by Mr. Simpson and instead spread out and laid flat on a flat surface?
Overruled.
Yes, they are. The stain is, I should say.
Okay. Now, I believe you testified earlier, last week, when we started the direct examination, Professor, that the ankle stain, even that portion of the ankle stain that's remaining, was visible to the naked eye when you examined it on April 2nd. Is that correct?
That's correct.
Now, you're a trained criminalist. Is that correct, sir?
Yes?
All right. In your expert opinion, sir, should other trained criminalists be expected to visualize the blood stain on the ankle with the naked eye?
Yes, they should.
All right, now let me ask you one last hypothetical, sir. Assume that on June 29th, 1994, 3 criminalists from the Los Angeles Police Department laboratory, Greg Matheson, Laboratory Director Michelle Kessler, and Colin Yamauchi, removed the socks from their packaging and laid them out on a white sheet of paper to inspect them. Given what you observed on April 2nd, would you have expected the trained criminalist on June 29th to discover the blood stain on the ankle had it been there on June 29th?
Objection. That calls for speculation, improper hypothetical, seems facts, not evidence.
Sustained.
Are you aware of the fact, sir, that Greg Matheson and Colin Yamauchi testified that on June 29th, 1994, they took the socks out of its packaging and examined it on a white sheet of laboratory paper?
Objection, Your Honor, seems facts, not evidence, calls for speculation.
I have the
Sustained.
transcript.
I know what they said, counsel. Problem is examined, is the word examined. It's a vague term in the context of this question.
All right. Are you aware of the fact that Colin Yamauchi and Greg Matheson testified that on June 29th, they removed the socks from their packaging and placed them on a white sheet of laboratory paper?
Yes, I have read that.
Okay. Are you aware of the fact, sir, that they testified that they looked at the socks at the time that they removed them from their packaging and placed them on a white sheet of paper?
Objection, that states the testimony.
Overruled.
Yes, I am.
Sir, given those facts, would you expect that those trained criminalists would be expected to have observed the blood stain on the ankle that you observed on April the 2nd?
Objection, that calls for speculation, not evidence.
Overruled.
Yes.
Now, right before lunch, I asked you some questions about body temperature. Do you recall that?
Yes, I do.
And I also asked you some questions, sir, where I asked you to literally read from the official records of the U.S. Weather Service. Do you recall that?
Yes, I do.
Now, you're not a meteorologist, are you?
No, I'm not.
You're not an expert on weather conditions, are you?
Well, as a layperson, yes, but not as an expert.
Okay. But you're able to read numbers off of this sheet, are you not?
Yes, I am.
And when I say this sheet, I'm referring to, I think,
1280?
1280, the official records of the U.S. Weather Service. And, sir, when you read those numbers, it revealed that the temperature range between the evening of June 12th and the morning hours of June 13th were between 63 and 66 degrees. Is that correct?
That's correct.
When earlier this morning you were talking about the different factors which can affect drying time of blood, does temperature affect drying time?
Certainly.
Will a stain dry faster at 90 degrees than at, say, 64 degrees?
Objection, no foundation.
Overruled.
Yes, it certainly will.
No further questions, Your Honor.
Ms. Clark? Oh, I'm sorry. All right, let me see counsel over the sidebar. With court order. Ms. Clark?
Good afternoon, Mr. McDonald.
Afternoon, Mrs. Clark.
Good afternoon, ladies and gentlemen. Mr. McDonald, you indicated that you've authored many articles, correct?
Yes.
And you've written a book that has since recently been revised, is that correct?
Yes, it's been revised twice, actually.
And the last revision was in 1993, is that correct?
That's correct.
Now, there was a paper that you presented, sir, as recently as earlier this year in Seattle, is that correct, entitled
absence of evidence is not evidence of absence. Do you recall that?
I believe Mr. Kish presented it. I co-authored it with him.
Yes, you are listed on the article as the co-author, were you not?
Yes.
All right, Ms. Clark, I'm going to direct you to give a copy of that to Mr. Neufeld.
I'm going to show you a copy as well, sir. Mr. Kish is entitled in this article as your research associate, is that correct?
That's correct.
I'll show you the article, sir, and ask you if you recognize it.
Well, this is the article. It's not been published yet, but it's basically the same thing. I hope it'll be published in this form.
That is the form in which you intend for it to be published, is that right, sir?
That's correct.
And you have presented this paper at a number of speeches that you've given, is that correct?
No, I've never presented it. Mr. Kish presented it in Miami in September last year, basically the same thing.
Nevertheless, sir, I suppose you would agree that you, even though he presented it, you co-authored it, and you stand by the principles that it espouses, correct?
Oh, absolutely.
Okay. And in that regard, sir, with regard to this paper, I want to ask you a series of questions concerning the contents. First of all, I'm going to direct your attention to the first page, the third paragraph, sir. I'm going to display it to you.
Yes, with court order, please.